Welcome to the deep dive. We take complex stuff and, well, we dive in to pull out what really matters for you. Today we're jumping into the world of patent examination, specifically MPP Section 2103. Now, the MPP, that's the Manual of Patent Examining Procedure. Basically, it's the rule book for patent examiners in the U.S.
That's it. The examiner's Bible, you could say. And this dive is actually part of a bigger series we're doing. We're going through the whole MPP section by section.
Okay.
So today, it's Section 2103, Patent Examination Process. It sits in Chapter 2100, which is all about patentability.
Patentability.
Yeah. So our goal is to break down how an examiner actually decides, step by step, if an invention gets that U.S. patent.
Okay, so picture this. An application arrives. What's the very first thing? Where do they start?
Well, the absolute first step, according to 2103, is for the examiner to really understand what the applicant is claiming as their invention.
Just read it.
It's more than just reading. It's a deep look at a few key things in the application.
Like what? Give us the breakdown.
Okay, so first, the invention itself. What is it? How does it work? Then, really important, is its utility.
Utility. Does it actually do something?
Exactly. A practical purpose. They also comb through the detailed disclosure, that's the big description section, and of course, the claims. Those are the really specific legal definitions of what the invention covers, what they want to protect.
Sounds like they need to become mini experts on the fly for every single application.
Pretty much, yeah. And there's this guiding idea called the compact prosecution model.
Compact prosecution.
Yeah, the idea is examiners should try and spot all the potential issues, all the reasons it might not be patentable right at the start.
Okay. So they flag everything up front.
That's the goal, to make the whole process more efficient, less, back and forth later on.
Makes sense. Efficiency is good. Now, you mentioned utility earlier. That sounds pretty basic, right?
Yeah.
A fundamental check.
It absolutely is. It's right there in the law, Title 35, Section 101. An invention must have a specific and credible utility. It can't just be like a neat idea on paper with no real-world use.
So if I invent, I don't know, a general feeling enhancer device, that probably wouldn't fly.
Likely not. That's too vague. It lacks that specific, credible utility. The examiner needs to see a concrete benefit. So once they feel they understand the invention and its utility, they move to the claims. Interpreting them, how's that done, right? Interpreting claims. They use a standard called broadest reasonable interpretation, or BRI.
Broadest reasonable interpretation.
Yep. They look at the claims, read them in light of the specification, that detailed description we mentioned, and give the words the widest meaning they can reasonably have.
And why is that important, that specific way of reading them?
Because it directly sets the stage for the next big step, the prior art search.
Okay. Time to see what's already out there. The detective work begins.
Exactly. The examiner does a really thorough search for prior art. Basically, any existing knowledge that came before the invention. Could be old patents, scientific articles, products already sold, presentations, anything public, really. The point is to find anything that might show the invention isn't actually new or that it would have been obvious.
So checking if it's truly novel and not just, a small tweak on something known.
That's the heart of it. And finding that prior art is crucial for assessing if the invention meets all the legal requirements for a patent. This is where the specific laws really come into play.
Okay, let's talk laws. What are the main statutes they're looking at?
Oh, there are several really key sections in Title 35 they focus on. We mentioned Section 101 already. That's about eligible subject matter. What kind of thing can even be patented?
Right.
Then there's Section 102. That's novelty. Is it actually new? Has it been disclosed before?
Okay.
Section 103 deals with nonobviousness. Even if it's new, was it an obvious step for someone in that field?
The obviousness hurdle.
Got it. And then there's Section 112. This one's got a few parts. It covers the written description. Is it clear and complete? Enablement, does it teach how to make and use it? And definiteness, are the claims clear about the invention's boundaries?
Wow, that's quite a list they check against. Can you give an example, maybe how something fails under Section 112?
Sure. Let's take Section 112B, definiteness. Imagine a claim uses really fuzzy language, like a substantially optimized component.
Substantially optimized. Yeah, what does that mean?
Exactly. If the application doesn't clearly define what substantially optimized means in context, the examiner might reject that claim. It's indefinite. The public wouldn't know what's actually protected.
Like trying to draw property lines with invisible ink.
Something like that, yeah. Clarity is crucial. Now, the outline also mentions correlating claims with the specification. Why is that linkage important? Oh, it's vital. The examiner has to make sure every single part of a claim, what we call a claim limitation, is actually described and supported in the specification, the detailed description.
So you can't just throw something new into a claim if you didn't explain it earlier.
Precisely. It has to be grounded in that main description. And it's not just checking individual parts either. Examiners have to look at the claims as a whole, especially for process claims, ones that define a method or steps.
The entire process gets evaluated.
Yes. The MPT even points to a famous case, Diamond v. Deere, emphasizing that you look at the whole claimed process together, not just isolated steps.
Okay, so they understand it, check utility, search prior art, run it through the legal checks like Section 101, 102, 103, 1012, make sure claims match the description. What's the next phase? Or the overall vibe?
Well, a really big theme throughout Section 2103 is communication. Clear, thorough communication between the examiner and the applicant. The whole point is to try and minimize delays and, frankly, confusion during the patent prosecution process. That's the back and forth we talked about.
So it's not supposed to be like a fight, examiner versus applicant.
Ideally, no. It's meant to be more of a dialogue. To clarify the invention, address the issues, and figure out if a patent is truly warranted. Good communication just makes everything smoother.
This has been really helpful. It feels like we've kind of demystified that black box of patent examination a bit.
I hope so. That's the idea. And this look at MPEP Section 2103 really shows it's a very methodical process. Examiners systematically check utility, the disclosure, the claim scope, the prior art, and all those legal requirements in Title 35.
So for you listening, hopefully this gives you a clearer map of what happens when someone actually files for a patent, the kind of scrutiny involved.
And maybe it makes you think a bit about the balance, right? How does this whole detailed, step-by-step process try to balance protecting inventors' rights with, the public interest, promoting innovation, but also sharing knowledge?
That's a good point, the balancing act.
Yeah. And if any of those specific sections sparked your interest, like Section 101 on eligibility, or Section 103 on obviousness, or Section 112 on clarity, you might want to dig into those a bit more yourself.
It's definitely food for thought. Before we wrap up, we should mention where this breakdown comes from.
Right. We should definitely thank Mike Shepard. He's the creative director who pulled together this whole MPP audio project. It's a great resource.
Absolutely. And just the standard disclaimer here. This summary was put together using AI tools like ChatGPT and Notebook LM. It's for educational info only. It might have errors. It's definitely not legal advice.
No substitute for the real thing.
Exactly. For the official word, always go to the official MPP documents or talk to a qualified patent attorney or agent.
Always the best bet for serious matters.
Great. Well, thanks for joining us on this deep dive.
Good talking about it.
Until the next one.